Not all legal conversations are technical. Some involve pain, loss, fear, or disappointment, and your words can either calm or escalate the situation. Whether you're guiding a client through divorce, delivering bad news about a case, or discussing traumatic events, emotional intelligence is just as important as legal knowledge. In today's lesson, we'll learn how to use professional, precise, and compassionate English when discussing emotionally charged legal issues. Today's lesson focuses on one of the most human and most difficult parts of legal work, talking about painful or sensitive topics. Maybe a client just lost custody. Maybe you have to explain that their claim isn't strong enough to proceed. Maybe you're discussing a traumatic event in a deposition or intake. These are not moments for legal jargon or cold logic. They require empathy, discretion, and clear but careful language. You will learn vocabulary that's professional and respectful. You'll practice softening devices like, it may be difficult to hear this, or you might want to consider. You'll also explore hedging, a way to avoid sounding overly harsh or certain when delivering complex or emotional information. By the end of this lesson, you'll be able to manage these conversations with both legal authority and emotional intelligence in clear, natural, advanced English. Let's begin by reflecting on your experience or what you imagine when handling emotionally charged legal situation. Think of a time when you had to speak with a client who was in pain, angry, disappointed, or overwhelmed. Maybe it was a custody case. Maybe it was delivering bad news about a judgment or a legal option they believed in. Or perhaps it was a client opening up about a traumatic experience, and your role was to listen with care while still providing legal guidance. You might say, one of the hardest conversations I've had was telling a client the appeal was denied. As a lawyer, it's important to stay calm when the client is angry or afraid. Even if the client is upset, we still need to communicate clearly and manage expectations. These are the kinds of conversations that define your professionalism, and your ability to handle them in English is just as critical as your legal knowledge. In legal settings, distress refers to emotional suffering. It can be short term or long lasting, and often appears in cases involving trauma, loss, or injustice. For example, the witness was clearly in distress while describing the events. As a lawyer or mediator, recognizing signs of distress helps you adjust your tone, pace, and language. You might say, if at any point you feel distressed, we can pause. We understand this is a distressing situation and will move carefully. Empathy is not about agreeing, it's about showing that you understand how someone feels. In legal practice, empathy builds trust and strengthens communication. For example, the attorney showed empathy without losing her objectivity. Clients don't just need legal advice, they need to feel heard. You might say, I can see how upsetting this must be. Or, I understand this is difficult. Let's go through it step by step. Discretion means using judgment when discussing sensitive issues. It's especially important in family law, criminal cases, or when trauma is involved. For example, the lawyer handled the client's story with complete discretion. It also refers to respecting confidentiality and knowing when to speak or when to remain silent. You might say, due to the sensitive nature of this matter, I will speak with discretion, or let's keep these details confidential for now. Confidentiality is essential in emotionally sensitive matters. When clients reveal painful or personal information, they need to know it's protected. For example, this information is strictly confidential and protected by privilege. You might say, everything discussed in this meeting is confidential. You're free to speak openly. Nothing will be shared without your permission. To deliver bad news professionally means being honest, respectful, and prepared. The phrase is often used when discussing outcomes a client won't want to hear. For example, she had to deliver the news that the appeal had been denied. It's not just what you say, it's how you say it. You might say, I'm afraid I have some difficult news to share, or this may not be what you hoped for, but let's look at your options. Grief shows up in many areas of legal practice: estate law, wrongful death, family law, refugee law, and more. It's important to acknowledge grief without making assumptions. For example, the client was still processing her grief when we began the estate planning. You might say, take your time, there's no rush. We'll go at a pace that feels manageable for you. Trauma affects memory, language, and behavior. When working with clients who have experienced trauma, legal professionals must communicate with care and sensitivity. For example, the witness had difficulty testifying due to past trauma. Understanding trauma-informed practice helps protect your client and your case. You might say, if you need a break, we can pause anytime. You are in control of what you share today. Clients may be vulnerable due to age, mental health, immigration status, or past experiences. Recognizing vulnerability helps you choose your language and strategy carefully. For example, children are considered legally vulnerable and require special protection. You might say, we will make sure your rights are protected throughout the process. If you are feeling overwhelmed, we can pause and go over this again. When delivering emotionally difficult legal information, tone matters. Even when you're being honest, how you say something can deeply affect how it's received. Softening devices help reduce the emotional impact of bad news. They're not about hiding the truth, they're about communicating with respect and care. Let's look at some of these examples. It might be helpful to look at this from a long-term perspective, or you may want to consider a settlement given the emotional toll of a trial, or there's a possibility that the outcome may not be in your favor. This may be difficult to hear, but the court rejected the application. Let's look at some of the options going forward. These phrases prepare the listener. They show compassion without weakening the legal message. In emotionally sensitive legal conversations, directness can sometimes come across as harsh, final, or even aggressive, especially when the news is not what the client hoped for. That's where hedging and indirect language come in. These tools help you express uncertainty or caution in a professional, respectful way. Let's examine how this works. For example, it seems that the court was not persuaded by the argument, or there may be some risk involved if we proceed with litigation. From what I understand, the judge tends to favor strict interpretation in these cases, or it's possible the court will request further documentation. Last one, we can't be completely certain, but this may not be the strongest strategy. These phrases allow you to communicate risk and reality while preserving trust and softening the emotional impact. They are especially useful when you're not giving advice yet, just managing expectations in early or difficult conversations. Now, let's apply what we have learned. We are going to take these direct and potentially harsh legal statements and rephrase them using the softening and hedging techniques we just reviewed. Here's how you might rephrase each one. Your case has no chance. There may be limited legal grounds to move forward in this particular case. You are clearly at fault. 2. It appears that the facts may suggest some liability on your side. Or, this won't work in your favor. 2. It's possible this argument may not be viewed as strong by the court. The court rejected your argument. The court seemed unconvinced by that particular point. Or, you didn't follow the process. There may have been a step that was overlooked, which could affect the outcome. This type of language reduces emotional tension, maintains professional tone, and helps preserve the client relationship, even in difficult situations. Remember, you're still being clear, but you're also being kind. break the news. This phrase is commonly used in both legal and medical professions when a professional must inform someone of difficult or painful news. For example, I had to break the news their asylum application had been denied. You might say, before we discuss next steps, I need to break some difficult news. We'll go through it together after I break the news. This phrase prepares the listener for something serious and sets a compassionate tone for the conversation that follows. Manage expectations. This phrase is central to the ethical legal communication. Clients often come in with assumptions or hopes that don't align with legal reality. For example, part of the lawyer's job is to manage the client's expectations about trial outcomes. You might say, let me manage expectations before we proceed. This could take several months. Or, I want to be clear about what's possible so we can manage expectations early on. This is a professional, respectful way to prevent disappointment while still being honest. Act in the client's best interest. In emotional cases, clients may push for outcomes that are unrealistic or even harmful to themselves. Your role is not just to deliver news, but to protect them legally and personally. For example, even when the news is hard to hear, we have to act in the client's best interest. You might say, my advice may be difficult to accept, but it's based on your best interest. Or, we will only take steps that serve your long-term best interest. This phrase reinforces your professional responsibility, especially in highly emotional situations. Respect the client's wishes. When clients are grieving, angry, or overwhelmed, they may still have strong views on how they want to proceed. Part of professional legal communication is recognizing their autonomy, even when you offer a different view. For example, the lawyer must respect the client's wishes, even when disagreeing with their approach. You might say, I'll explain the risks, but I will respect your decision. As long as you're fully informed, I will respect your wishes on how to proceed. This phrase shows balance. The client leads the decision, but you guide the process. Let's wrap it up with a story. You're meeting with the client whose immigration petition was denied. She's been waiting for over a year and believed the outcome would be positive. She's under emotional strain, and this conversation must be handled with care. You begin. I'd like to start by saying that everything we discuss here remains completely confidential. I understand how much this matter means to you. Then, with empathy and caution, you prepare to break the news. This may be difficult to hear, but I want to let you know that the decision from the immigration court was not in your favor. You pause, observe her reaction, and continue gently. I know this is distressing, and I want to go through it step by step so you understand what happened and what options may still be available. You use hedging and softening to keep the tone respectful and calm. You say, it seems that the court focused heavily on documentation gaps. There may have been some misunderstandings in how certain evidence was interpreted. As emotions rise, you manage expectations. You say, it's possible that an appeal may not succeed, but we will look closely at the decision and discuss what's realistic. My role is to act in your best interest. She insists she wants to fight the decision. You reply, I fully respect your wishes. Let's take a look at what legal avenues still exist and see what's feasible from a strategic standpoint. You close the meeting with clarity and reassurance. I'm here to support you through this, not just legally, but professionally. And we'll take the next steps together. This is how legal professionals communicate hard truths with professionalism, tact, and humanity, especially in the moments that matter most. Let's review what we focused on today. You learned how to speak professionally in high-stress legal situations, moments when your clients are afraid, grieving, or disappointed. We covered advanced vocabulary to describe emotional and sensitive issues, and practice using softening and hedging strategies to reduce the emotional impact of legal communication. You also learn 4 key phrases used in law and legal practice when dealing with emotionally complex matters, from breaking the news to managing expectations and respecting client autonomy. Finally, we brought it all together in a storytelling simulation, showing how to speak clearly, respectfully, and compassionately, even when the outcome isn't what the client hoped for. This is what true legal communication mastery looks like: not just technical accuracy, but emotional intelligence and language precision.